Good afternoon. This is Media Center, Ukraine, Odessa. We continue for today. And now, instead of a briefing, we are going to have an unusual event for us. This is the panel discussion dedicated to the topic, the jury trial in Ukraine and judicial reform, about the legacy of Andriy Portnov. Our participants: Mykhaylo Baimuratov, Doctor of Law, Professor, member of the Scientific Advisory Council at the Constitutional Court of Ukraine; Andriy Perov, attorney, PhD in law; Valery Sudakov, attorney and moderator; Leonid Shtekel, editor-in-chief of Odesa Daily, and he is also an initiator of our today's event. The floor is yours, Leonid. Thank you. Today we are going to discuss the heritage of Mr. Portnov. I want to remind that in the 2000s, Andriy Portnov was a legal advisor, an attorney of Ms. Tymoshenko, and when Tymoshenko was sent to jail, he joined Yanukovych and became his legal advisor. In 2011, in 2012, when Yanukovych created a new legal form, quasi-representations of the people. One day we will discuss this as well. But the legal and procedural code developed by the managed lawyer, Portnov. This code is still in force, but it contained a lot of elements that in reality meant completely different things than it was mentioned. So today I would like to discuss the real notions and the real senses and its efficiency. Before we start our discussion, I would like to remind that it is believed that democracy is when the percentage of legal trials and the positive decisions is different and quite versa. And we can also speak about China when the situation is completely different, because they have a small percentage of acquittals. In Ukraine, it used to be 1%. In the United States, 25%. And we also had the round table to discuss the new legal procedural code. And the representatives of powers told back then that the new legal criminal and procedural code will allow to increase the number of acquittals. And that was the aim of new elements of the procedure. And now it would be great to learn about the opinion of practitioners to understand what are the results of those criminal procedural code and so-called jury trials over the last decade. And it is very interesting to learn from the people who were aware of this, what is the difference between the real jury trial and the trials that were created by the mentioned Portnov. Andriy, the floor is yours. Don't forget to introduce yourself. My name is Andriy Perov, attorney with 25 years of experience. And I'm also a professor of the legal department of the Odessa institution and a docent. And so I also have a real practical experience. And I would like to say that we would honor too much if we try to summarize this doubtful activity of Mr. Portnov. Excuse me, Andriy, I would like to say that not only jury trial was established back then, but so-called the public courts. There were a lot of quasi-bodies that were supposed to substitute some real entities. I'd like to say a few words about the history of the question. Jury trials in Ukraine were in the part under the Russian Empire and in the regions that were under the Austrian Empire. Then there was the Bolshevik revolutions who conquered Ukraine, and in the 1920s, after the revolution, the law was cancelled, and there was the revolutionary conscience that ruled everything. In our difficult times, in our turbulent times, when we tried to fight justice, some people believe that the legislation should be cancelled, but this is an outdated approach. I'm not going to consider this in details, and I would like to offer to consider transformations after the 1920s. In the Soviet times, there was kind of a proto-jury trial. So there was a judge and so-called people's assessors that were elected among workers on different enterprises. Was it really a jury trial? It is difficult to say so, and it was had more decorative nature and a lot of other things in the Soviet times. I'm sorry, Andriy. I'd like to interrupt you a bit. During Perestroika period, I talked to such assessor, or it was a woman. She was an IT expert, and she was a juror. And we discussed the topic with her in 1980. And she told that she and her friends were not of a decorative nature. They really discussed the case with the judge, and they were actively involved in the process. But this actually proves that this was kind of an exception, and but the practice was that they had just to nod with their heads to support the judge. But this is not the topic of our today's panel discussion, because we are not going to discuss retrospectively the jury trial, but the shameful heritage that we got from Portnov. But I wanted just to provide some brief information about the different periods to give background for our today's discussion. When Ukraine became independent, there were also some transformations. And the transformation in the law and in social sciences means substitution of the established practices with the new ones. There was also a need in the jury trial, and in our current legislation, in Article 387, 31 of the Criminal Procedural Code, and also Article 124 of the Constitution, that says that people should be directly involved in the legal activities. It seems to be right. But in reality, people are not directly involved in justice because there are the questions to the skills and knowledge of the judges, and there is still the Soviet practice when a lot of issues are decided by the phone call. But they should be the servants of the state, because the state pays such judges. And the same could be told about the jurors. Local councils framed jury trials, and in Odessa, those people who did not support the revolution of dignity became assessors, people's assessors. I saw that once. Our country is still young, and only now it has professionals in this area. We are today here, the colleagues, attorneys, and you, the well-known journalists, who can now accumulate the experience over the last 30 years to understand pros and cons and to decide what we need in the future. And in the future, we need the following. There is the war in our country now. The war has led to the fact that there is an increased demand for justice. And we, as professionals, as scientists, as public figures, can support our state, not with HIMARS, because that is the practice of the military, but we need to change the existing practices in court proceedings. And I'm a liberal, and I believe that the legislation should be fully updated. But Mykhaylo Baimuratov is conservative, and he believes that we need just several reforms. That's why we need to offer this discussion to the society, because when our defenders come back from the front, we will be able to submit to the Verkhovna Rada draft laws to boost the reform. And the business can do the same for agriculture. Some other public figures can do the same for the social area. This is very important because after the martial law, we should start improving the situation at once to make our life better. I have a proposal to you. I would like to ask our attorneys to answer two questions. How do you think what we have now, which is called the jury trial, is it in line with the traditional standards of jury trials? And are the changes of Andriy Portnov allowable in general? And it is important to understand if jurors are involved in trial, or is it more of a decorative nature? What is your opinion? And I would like to ask Andriy and also Mykhaylo. I can give floor to my colleagues. Valery, what do you think about this? Jurors, the novelty of 2012, and we used to have the people's assessors. We had a judge and two people's assessors in the court, and the court was called People's Court. And now these people are called jurors, and for some processes, like the court proceedings for acknowledgement of inability, for appeals, etc. So we used to have it for criminal cases, and there was the regional court of the first level, of the first instance, and the same is for appeal. But this is not the topic of our discussion. Ukraine didn't risk to introduce the American model of jury trial when jurors are independent from the judges. And in the first draft law of Portnov, that was the United States model, but in the first reading there were already amendments because they believed that it was too risky for the state and for the leadership of the state because they didn't want to have fully independent jurors. And judges usually say that the jurors should follow their institution and experience as it is in the United States. But in our case, we still have people's assessors. The judge can persuade jurors to vote as he or she wants, but the jurors can support the acquittal. But if the judge is the part of jurors, of course, he or she can affect the process a great deal. And the main problem of our jury trials is the regional issue. And there was one case where I participated, and actually that was about adoption, and it was clear that a man wanted to adopt the third child to avoid mobilization, and there were two jurors, old ladies, who did not want to allow adoption because they were afraid that that man could rape the 15-year-old girl, and they did not want to support that. And it was, and so we wanted to persuade those elderly women that they were wrong, and so they supported the adoption. And I don't think that in such case, when we have such jurors, I would entrust our case to such jurors. So there is the right. Of course, I can explain this to our clients, but it is quite questionable because, of course, all of us are well aware of the American films that there are jurors who are independent and who make usually the wise decision, and quite often this is an equivalent, so there is a happy end. But this is not our reality. And here we speak about the psychological impact on jurors. Plivaka is a well-known lawyer, and he knew how to select the key phrases, and there was a famous case of the priest who raped a woman, and he said to jurors that that priest for 15 years delivered from evil everyone, and so they should support acquittal. What is the problem? Jurors are not aware of the law, and it is very funny to see in the American movies when the juror says that when the judge says the jurors should not take into consideration some phrase. So for the members of the process, it is very important to say some phrase to affect jurors, and the judge, of course, can say that it should not be taken into consideration, but they cannot affect the juror. And if we have a professional decision by the judge, usually there are many pages with the evidence. But if we have the decision of the jurors, then it's only yes or no. And it is very difficult to work with such decisions. That's why in the form that we have, and the jurors are under control of the judge, and this is a more European system, and I Googled the topic. Most European countries have adopted the system that we have now in Ukraine, when the judge is involved in the process and can affect the decision of jurors. And judges can explain a lot and saying that there are different types of evidence that should be considered. But the jurors cannot make a decision on their own because they do not have the legal background. It is very important to select proper jurors, experienced jurors, skilled jurors for the process. And usually both parties can ask a question. I had the case with the driver who killed an 8-year-old boy. And if we have jurors like mothers of such boys, of course, 8-year-old boys, of course, they would like this person to be sentenced. But there could be some other jurors. And it is very important to select how the jurors are selected. This should not be motivated to people. A psychological aspect, there was a movie, there was a film, when a person offered his service of a psychological impact on jurors. And he followed the proceedings and provided information about jurors, about their response to different phrases. And he also advised to look at the eyes of jurors. But this also works because these are psychological aspects. We're not that experienced in our work with jurors, but sometimes we do not need to use some legal evidence. We should use some phrases that can affect on the psychological level the jurors. And I would like to add a few words here. When it comes to jury trial, our society is now more mature because the thing that was offered during the Soviet time and the transformation further on and targeted the cases with the professional judges who is responsible for the fair process. But we believe now that our society becomes even more mature, and now we have enough knowledge, skills, competences to distinguish between what is good and bad. I've read some social media, and I can see that people have become more experienced now. They have more knowledge. And I still remember what you've mentioned about Portnov, and we have the code of Napoleon 1814, and it still works there. But what Portnov offered, that was kind of a parody and a manipulation. And it was kind of a jeer. And we could see actually the trial over Yanukovych and his representatives tried to create some chaos back then. What I want to say now, we need to develop some psychological types. We can use literature, cinematography, and the writers could also do the same, just to introduce this new trend. I have a question to Valery. Valery, I wonder, have you ever read about the trials, the jury trials in Russia, about their practice? Because they introduced jury trials earlier than we introduced it in Ukraine. Yes, that was back when there were some liberal times there, and they have introduced jury trials that covered almost all articles, and it was during the Chechen War. And why Russian leadership was afraid? Because they were rigid. Those trials were regionals, and there were a lot of acquittals back then of the so-called terrorists, saboteurs, and the leadership was afraid. And they narrowed the list of cases that could be covered by jury trials. And in our cases, there are some severe situations which are covered by jury trials. And actually, as for Russia, we have the newspaper of Odessa. advocates. This is the latest edition, and it can be also found online in a digital form. We remember there was a big case of Vera Zasulich, and a girl had her boyfriend. The boyfriend was beaten in prison, and she tried to shoot the head of the regional police, and there was the acquittal. But then it was transmitted to the military tribunal, but she managed to escape. Jury trial is an element of a democratic society. And if there is no demand for jury trial, there is no demand for the democratic regime, they turn into the field courts to make decisions on the spot. Valery, you're a practitioner, and is there any practice of jury trials? What is the percentage of the proceedings are covered by jury trials? The defendant can choose this, yes, but this is for severe criminals where the life sentence is possible. I do not have such experience. I have an example that was the case of Yusuf, the person who tried to kill Yusuf, and the proceedings took around 7 years. The criminal availed the opportunity to select the court, and he orally selected one judge. But when the case was submitted to the Supreme Court, the person told that he was not explained what to do, and the documents were not signed. That's why the process was started all over again, and it took for around 7 years. When a person selects a jury trial, you need to understand that those people who you often meet in public transportation will be your jurors. Jurors are usually elderly people who have nothing else to do. And also those people who will be responsible for forming jury trial. And we know the interests of our local authorities. So they can recruit jurors amongst street cleaners. I have one more question to you as to practitioners. How do you think over the last decade, over the last 80 years, are there any changes in the percentage of the acquittals in the country? Yes, I can speak about my own practice. There are more sentences now. And the idea, the strategy of the new code do not support acquittals because the additional investigations were cancelled. And when the judges used that possibility of additional investigation as a substitution for acquittals, now there is no such institution that allows to return the case for additional investigation. There is no such option for the judge. Now there is the list for the specific cases of the corruption cases and some other cases where there are amendments. When there can only 2 options, sentence and the acquittals, and now there is the increased number of the acquittals. Because in the past, judges tried to persuade those who gave bribes to agree for something, to have some options. But now there is no such option, and now the number of acquittals has increased. But we have the achievement. This is the cancellation of the additional investigation after court proceedings. And now we can give floor to Mykhaylo Baimuratov. And just want to remember the times of Pshonka, the prosecutor general, and and why we fight against the acquittance. And the system in the United States is different, and this is okay to lose or to win a case for prosecutors. It's like for boxers, and this is not a problem. But in our case, if there are the acquittals, then there will be official investigation, and quite often prosecutors ask judges not to agree upon acquittal. And now I believe that the Andriy Kostin, who is from Odessa and who is the prosecutor general, will change the situation. And this is a very honored person, and I believe that he will be able to improve the situation. At the collegium of the prosecutors, Pshonka told them that he would not blame them for their acquittals, and that was gave some boost to the acquittals. But after Pshonka, there was another person, and the number of acquittals decreased. So should we appoint some new prosecutor general to know about his position in advance? Mykhaylo, the floor is yours. So let's differentiate between different notions. We need to say that jury trial, we need to agree to this, that this is an element of the democratic society, and it is a characteristic of the phenomenon of the legal democratic state. Vocum populi, vocum Dei. This is the voice of the people is the voice of God. And this is how it is established. The Russian experts say that it was the jury trial was first introduced in 1964 in the Russian Empire, but in Western countries there is quite significant experience of how to form such trial, and our model has nothing in common with the United States model. Our colleague has mentioned already different films, and when I teach my students, I always say that can you see a huge bookcase with the books in the cabinets of Eternus. And this is the sign of the precedent law that was first introduced in the 13th century. And still there are new cases added basing on which the judge makes a decision. But when we have a classical scheme of jury trial in Western countries, then jurors can make a verdict about the guilt. But this is up to judge to decide what sentence there will be. But we have a kind of a mess here. And the judge tries affect the jurors. Jurors try to find evidence to support their position, but their position does not rely upon the law, because we have here a quite significant problem. I used to tell Portnov that we introduced jury trial a little too soon, because there is the legal nihilism, there is no legal psychology, no legal consciousness, no legal ideology, and the lack of all the things led to the fact that that was not the real jury trial, but kind of a mockery, kind of a profanation. People are just dressed like jurors, but they are not real jurors. As for the efficiency of such trials, I believe that without proper training of Ukrainian citizens who can become jurors is at the zero level. There is no efficiency. That's why there are quite interesting proposals now that people will come back from the front line, from the combat zone sooner or later, and there will be requests from them for justice, for a specific legal order, and we need to offer some solutions to them. But how can we offer such solutions if we have not started even discussing such issues? And now, to make jury trial possible, to form it at the proper level, we need to ensure a proper training, proper educational system. And I also think that the criminal procedural code shall be respectively amended to ensure a proper code of conduct for jurors. Because we work with jurors as we work with witnesses or victims or defendants. Here, we need to introduce the proper state policy. If it's a positive policy, then we will have a positive effect. If we will try to regulate everything as under the martial law, and we can see the efficiency now. There are corruption cases when the money can be taken from the military and then can be partially brought back. Then again, we will have no effect. No result at all. We can say that there is a problem, it is important, and we need to find solutions. But we need to take the whole complex of measures to solve it. I have a question to all participants of our panel discussion. The English law, the 10th century, the first document of English law was about the transition of management. But I speak about the unwritten constitutions of the Great Britain. In Greece, it was the 14th century before Christ. I would like to explain why I'm now mentioning the 10th century. In the manual of the law, of the legal science, it is told that the first document, which is the basis of the modern law, is the 10th century, the English law. But now I would like to speak about different precedents. I don't know how the situation was in the Austro-Hungarian Empire, but I know that in the Russian Empire during Nikolai I, the court system there was totally corrupted, and it is described in the famous place of Ostrovsky, who was the secretary in one of the Russian courts. So then there was the change of power. There was the new Tsar, Alexander II, and during 2 years, the court reform was conducted to introduce the jury trial, and they leading to zero court corruption there. Of course, there was corruption in other areas, but the difference was quite huge comparing the times of Nikolai and Alexander II. And it is impressive. So they were managed to reform the court system, introducing the jury trial. How do you think? Can we repeat this experiment now? Or the situation is quite different now? I'm just interested in your opinion. From the scientific point of view, we can say that we can do even more. So now we have neural links. We can entrust this to computers. No judge, no jurors, and the computer will just make an unbiased decision. And we should also remember about significant funds which would be invested in the jury trial. I would like to say a different thing. The juror trial is the significant inclusion of the population in the life of their country. As it has been mentioned by Mykhaylo Baimuratov, that we need to show to start the dialogue involving mass media, to raise up new citizens, what they didn't have during the Soviet times. The war now is raising up the new responsible citizens of Ukraine who strive for justice. We can modernize the jury trial, but this is not only the only way out to achieve fair justice. Just a small remark from my side. Andrei, I would like to offer you to read Stanislav Lem and about the Pirk's pilot. And it really shows greatly the philosophical aspect of the artificial intelligence. Valery, what can you tell? One of the factors that supports jury trial, it is very difficult to bribe all 12 jurors. And of course, now in our case, it is the biggest amount of money needed to give bribe to judges. And actually, there were different films showed how the jurors could be affected, and usually not so many funds were needed to persuade jurors to vote for something. That's why I'm not sure that we can fight corruption. And we come back here to the question, what people could be recruited as jurors? If these are people from the public transport that we meet every day, then I could not support this. And I would also like to say about the American system. And actually, I learned there to become military lawyer, and they have the different system, and there are judges, lawyers, and we can see the films there. And there is the preparatory stage. At this stage, the judges explain to defendants that there are three options. The first one, you say that you are guilty, and in 15 minutes there will be the softest sentence. The second option, you say that you are not guilty, but you, judge, please should consider this case individually. I can consider this case, and there will be some medium-level sentence. They're kind of agreement with the judge, but this is kind of a simplified procedure. We also have it. And the third option, when the person is said not guilty and opts for the jury trial. Judges say that, okay, and this is the most expensive option. And if they say that you're guilty, then the sentence will be the most severe. Why are you talking about this right now? Because actually we can see that the jury trial is for not 100% cases in the United States. But of course, we need to offer such an option of jury trial. This is for the defendant to select. I'd like to say that we need to increase the spectrum of different judges, of different forms of the trial. For this service to be accessible. We need different charges for car accidents, more maybe for taxes, for labor, for family issues, for residential issues. So we need to move in several directions to solve the issue. So we need to define the specialization for courts. And we also need to improve or reform the jury trial according to the demand of our society now and after the war. Just to summarize our discussion, I would like to say the following. Judges are afraid of jury trial, especially those judges who love corruption, who encourage the development of corruption, etc. And if we consider the existing model of the jury trial in Ukraine, then this model cannot prevent corruption. When a judge, in the framework of court proceedings, and during discussion in a separate law can affect the decision of jurors, there is no guarantee that we can achieve justice. Sooner or later, we will have to opt for the American model. Sooner or later, we will see the necessity to involve citizens in the jury trial who have the minimal legal consciousness. Because we cannot involve the professional lawyers, and this will be included in the law now. But now the new topic, the so-called para-lawyers. So the work, but we need to start this work at once. We need to start this work now. Otherwise, the jury trial will be a democratic institutions of the formal characteristics. I would also like to note that from the antique times, there were procedures that we can still see now. So now we have the symbol, the Themis, but in the ancient times when there was Zeus, and the goddess also of fairness. When I use the tie, there is a sign of that I'm an intangible person. And I would like to offer for the judges, you have not only Themis, but also the goddess of fairness, for us to see the flag, the Themis, the goddess of fairness. And then the judges will take more money. Thank you. I'd like to thank all the participants of this quite interesting discussion. I've learned a lot of new from the discussion, and hopefully our audience also finds this interesting. Thank you very much to everyone. Unlike this was the discussion about the jury trial in Ukraine. Is this institution is efficient? Can it be called the jury trial? And this is the last event for today in our center. Please stay tuned and see you later.